Good morning. Is there a representative on 23-00913 portfolio recovery? Is that you, Ms. Francis?
Good morning, Your Honor. Yes, I'm here for portfolio.
All right. And is there a Yukalov Winston? I think I see Mr. Winston or Miss Winston. Is that you? You'll have to unmute.
Yes, thank you.
All right. And are you represented by counsel today?
No.
All right. And Mr. Kazmarek, are you here on the following case, the PCI Calhoun Clinton case?
Yes, Your Honor.
All right, Mr. Kazmarek. And then Arden Rawl, are you here on that case? All right, I'm going to call the case of 23-00913, portfolio recovery versus Yukalov Winston. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff.
Hi, Yukia Love Winston.
All right, and this is the time set for a pretrial in the matter. Ms. Francis, if you had the opportunity to speak with Ms. Winston, I do have a pretrial statement that we could fill out, but I'd want to give the parties the chance to talk if they're amenable to such. So Ms. Francis, if you had the opportunity to speak with Ms. Winston?
I have not, Your Honor.
Oh, Ms. Winston, would you be amenable to speaking with Ms. Francis concerning this pretrial and pretrial statement?
Yes, Your Honor.
All right, so Ms. Francis, what I'm going to do is I'll put you in a breakout room with Ms. Winston. I have a pretrial statement form that we can, on the record, fill out, and I can get your authorization, or each party can fill out the form. It's probably easier if I fill out the form, but I'll give you the opportunity to speak about the case. It's a little premature with some of it, such as expert witnesses and damages, since this is a little early in the timeline. But I'll let you guys talk, and then we'll go back and put it on the record. All right, ma'am?
Okay, thank you, Judge.
All right, so I'll have Ms. Francis and Ms. Winston placed in a breakout room. And then similar to that case, we have docket 23-01503, that's PCI Calhoun Clinton versus Arden Rawl. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Joshua Kazmarek, P80941 for the plaintiff.
Good morning, Your Honor.
Thank you.
Arden Rawl.
And sir, you're an Arden Rawl? All right. Similar to that case, this is the time set for pretrial. I have a pretrial statement. It's a little early in the litigation for it, but that's our time frame. Mr. Kazmarek, have you had the opportunity to speak with Mr. Rawl concerning these legal issues?
I have not, Your Honor.
Mr. Rawl, would you be amenable with Mr. Kazmarek just speaking about some of the legal issues before we place the pretrial on the record?
No, yeah. There was already a judgment in this matter against me 5.5 years ago in Clinton County. That's why I don't understand why there's.
Don't tell me anything about the facts, or just if you and Mr. Kazmarek want to talk about this somewhat, and then we'll come back and place the pretrial on the record. All right, sir?
Okay, sure, yeah.
Your Honor,
Mr. Kazmarek?
I apologize. I do have another hearing coming up in another court. There aren't really issues of law. There's more issues of facts that I think we could get resolved with some simple written discovery only.
Did you just want to fill out the pretrial today then?
If we could, Your Honor, I would appreciate that.
All right. So I'm going to indicate for the record, this is for docket 23-01503. What I'm doing, Mr. Rawl, is I'm just filling out a pretrial statement with an indication of some of the issues in the case and some of the talking points in the case, and then that'll start the ball rolling as to discovery. All right, sir?
Okay, yes, sir.
All right. So I'm gonna have, this is PCI Calhoun versus Arden Rall. The parties at pretrial conference was heard on today's date, which is July 20th, 2023. And Mr. Kazmarek was here for the plaintiff, and Arden Rall was here for the defense. And you were indicating, Mr. Kazmarek, what were the legal issues concerning this matter?
Plaintiff's claim is simple for breach of contract to count stated in unjust enrichment, Your Honor. I believe there's issues of fact here in regards to the defendant's answer. Plaintiff brought its claim. It's a manufactured home community. This is unpaid site rent. It's not a home lease. Defendant's raising issues with conditions of the site itself. So I believe that's the factual issue that needs to get fleshed out between the parties.
All right. And so this is based on, the only thing that's been filed at this point is the filing of complaint and the proof of service. Is that correct?
And the defendant's answer, Your Honor.
All right. Do you intend to file any further motions, Mr. Kazmarek?
Reserve the right to file a dispositive motion, Your Honor.
All right. And Mr. Rall, I'm assuming you'll reserve the right also?
Yes.
I'm going to indicate that it's too early in the process for admissions of fact. Anything on exhibits?
To be filed 14 days before trial or whatever is the court's custom, Your Honor.
Yeah, within 14 days of trial, but it's awfully easy. It's awfully early in the process without some discovery. You indicated that the parties need to talk for a period of time. How long are you looking at discovery in this matter, Mr. Kazmarek?
No more than 45 to 60 days or whatever's the court custom, Your Honor.
All right, let's do 90 days, just July, August, September, October. We'll do October 20th, which is a Friday. I'm indicating on expert witnesses within 14 days of trial, same. Has either party paid for a jury trial, or is this a bench trial at this time?
It's
Mr. Kazmarek?
It's a bench trial,
All right.
Your Honor.
All right. Mr. Rall, I'm assuming you have not paid the fee, so it's still a bench trial?
Correct.
I'm going to indicate based on the party's comments that there is a possibility of settlement. Do you see evaluation or mediation as a option in this case, Mr. Kazmarek?
I don't believe it's necessary, Your Honor.
Okay, Mr. Rall, I'm assuming based on some discovery, it's a little early to make those claims.
Correct.
All right. Do I have your authorization to sign this, the pretrial statement on your behalf, Mr. Kazmarek?
Yes,
And
Your Honor.
I can read it for the record, but we just went through it.
Yes, Your Honor.
Mr. Rall, do you have any questions about the document, and do I have your authorization to sign? Really, nothing's been done today except put some timelines in. And the big one being discovery it will be due by October 20th of 2023, so that we can keep this case moving. I understand there's some factual dispute that you and Mr. Kosmeric can work out at some date concerning this, but do I have your authorization to sign this pretrial statement today?
Yes, sir.
Thank you.
All right.
All right. I will indicate that we've had the pretrial conference. I've signed the document. Both of you will receive a copy of this document that will be mailed out to you. And then I'll let each party talk before the intended discovery date to flush this out and await any motions or any further sign of resolution in this matter. Is that appropriate, Mr. Kosmeric?
Yes, Your Honor.
All right. Mr. Rawl, do you have any questions of me?
No, sir.
All right. I'll let the parties talk about this, and then we'll see any date. You should get a copy of the pretrial statement, and both of you are all set. Thank you for your appearance today.
Thank you for your time,
Thank
Your Honor.
All right. Here's that. This is the two co-defendants. All right. Let's go ahead and put that on the record. That's a good idea. I'm gonna move that. All right, Mr. Marshall, correct?
Yes.
All right. So we're on the record in dockets 23-01964. That's people of the state of Michigan versus Abdullah Thompson. Omar Abdullah Thompson. And docket 23-01963. That's Dayton Rick, people of the state of Michigan versus Dayton Rick Athlete. Will the parties please introduce themselves on that file? Let's start on the first file on 23-01963. Mr. Marshall.
Bob Marshall, on behalf of the people, Your Honor.
All right. And counsel?
Morning, Your Honor. Ron Berry appearing on behalf of Omar Thompson, who is standing to my right.
All right. So I think we're doing Ackley first.
Morning, Your Honor. Rico Neal appearing on behalf of Mr. Ackley, who was present at the podium, standing to my right.
All right. And that's 23-01963. All right. And these are co-defendants, so let's go ahead and do them together. I'm sorry, Mr. Berry. We can also go on 23-01964. And Mr. Marshall, you're also here on that case.
Correct, Your Honor. Bob Marshall, on behalf of the people.
All right. And Mr. Berry, you've introduced yourself for the record on Mr. Thompson. And, all right. So sir, you are Rick Dayton Ackley, is that correct?
Yes, sir.
All right. And sir, you are Omar Thompson, is that correct?
Yes, sure.
All right. This is the time set for preliminary examination on both files. I want to do Mr. Ackley first because there was an indication of a request for evaluation. Mr. O'Neill, my understanding is you're withdrawing that request at this time?
Yeah, that's correct. And actually, it was my understanding that the victim has failed to appear. As such, the people are unable to meet their burden of proof, and now the process has been filed in this matter. So we are withdrawing the request for revenge.
All right. All right. So let me make that indication for the record, just so the forensic request has been withdrawn. All right. So this is the time set for preliminary examination. Mr. Marshall, it's my understanding, based on the Nolly process I have in front of me, the people are unable to proceed today.
That is correct, Your Honor. The necessary victim has not appeared today.
And that victim was subpoenaed?
Correct.
And has your office had any contact or recent contact with a victim to speak of?
No, Your Honor, not to my knowledge, unless something was not put in the notes from the
All right.
previous prosecutor. I would note that I did let defense counsel know that if we are able to locate, that these would be reissued. This victim is homeless, so we did make attempts to contact, but he does not have a phone.
All right, so in regards to both files, and I'll treat them one at a time, just so we don't confuse them. And so it's your request today, Mr. O'Neill, for dismissal concerning Mr. Ackley for the
Yes, sir.
prosecutors unable to proceed today.
Yes, that's correct, Your Honor.
All right. Based on the representations made by the prosecutor in this case and by Mr. Ackley, I'm going to grant the motion to dismiss and sign the nollie process based on the interest of justice. I have it right here concerning the nollie process on the case. I'll sign that. What this means, Mr. Ackley, is for our purposes today, the case is dismissed. This people may reissue if they choose to, but for our purposes today, it's dismissed. All right, sir? All right. So I'll indicate, go ahead, Mr. O'Neill.
If I may, if the people do intend to reissue at some point in time, I ask that they give us courtesy call so that we can self-surrender.
That seems like a reasonable statement, Mr. Marshall.
I will make a note of that in the file.
Right. Yeah, make a note in the file that if it is reissued, again, you're able to find the witness. Mr. O'Neill should get a courtesy call so you can line up his witness.
And I will do the same for
Right.
Mr. Murray.
All right, thank you. All right, so the nollie process signed as to Mr. Ackley. And then I will go as to Mr. Thompson. For similar reasons, the prosecutor is unable to proceed on docket 23-01964. The complaining witness has failed to appear and has been subpoenaed. Mr. Berry, do you have a request to the court concerning the preliminary examination?
I request that the court grant the nollie process.
All right, based on the people's representations, the request for dismissal is granted. I have a nollie in front of me indicating in the interest of justice for the people's inability to proceed without a complaining witness. So what this means, Mr. Thompson, is today the case is dismissed without prejudice. Without prejudice means that the people could reissue if they choose to. But for our purpose today, the case is dismissed. If it is reissued, Mr. Marshall's indicated for the record that he's making a note that Mr. Berry will be notified, and if they reissue, you'll be notified by Mr. Berry, okay? Okay, yeah. Do you have any questions, Mr. Berry? No. All right, thank you. All right, so the case 23-01964 is also dismissed pursuant to nollie pros. Anything else for the record, Mr. Neal?
Nothing further on this record, Your Honor.
Mr. Berry?
No, Your Honor.
Mr. Marshall?
No, Your Honor.
All right, you're all set. Thank you for your appearance today.
Thank you, Your Honor. Your Honor, if I may,
Yes.
on a separate matter, I did inform APA and your court staff, I have my 1:30 with you this afternoon. My 1:30 is present. That will be a waiver.
All right, we can do that if you'd like to.
Yes, please.
Yeah, let's see that. That's the top. The top file. Are they co-defendants?
There is a co-defendant. The co-defendant did retain new counsel yesterday.
Okay.
I believe they're going to appear this afternoon.
All right, but we can do that. You can.
Your Honor, if I may, I did get an email from the new attorney on the co-defendant. He was going to reach out to the court this morning. He has his docket in 54B, his city docket, I believe. So he was going to reach out to the court to see if he could appear early, I believe as well, sometime via Zoom. I'm not sure if the court received that email. I'm just passing along what I received.
We have not received it. Is Mr. So that this is Mr. Kelso we're talking about,
I'm
right?
talking, Kelso's my client.
Right.
Yep.
And then so we do have a substitution for Mr. Easterly. So Mr. Marshall, do you have any objection to the waiver on Mr. Kelso today?
No, I do not, Your
All
Honor.
right, and then, so if you've got your guy here, let's go ahead. And I'll need that file. That'll be the very top file on the table. Mr. Kelso. Thank you, Nathaniel. All right, without objection, and let's go ahead and put docket 23-01881 on the record. Will the parties please introduce themselves for the record?
Yes, Your Honor. Bob Marshall on behalf of the people.
Good morning again, Your Honor. Rico Neal, appearing on behalf of Mr. Kelso, who is present at the podium, standing to my right.
And sir, you are Idris Kelso?
Yes.
All right, thank you. This is the time set for a preliminary examination. It was set for 1:30. We're addressing this case early, and it's my understanding was set for preliminary examination this afternoon. Mr. Marshall, how are we proceeding today?
Your Honor, the defendant in this matter would like to unconditionally waive his right to the preliminary exam. The people would do the same, and we would ask that this court bind this over to the circuit court on all the charges in the complaint.
All right, and is that an accurate statement, Mr. Neal?
Your Honor, that's a correct and accurate statement. I've explained to my client the nature and the purpose of the preliminary examination, which he fully understands, and at this time he intends to waive his right to the exam and have this matter bound over to the circuit court.
All right, thank you. May I address your client concerning his waiver?
Yes, you may.
All right. Mr. Kelso, you understand that you have a right to a preliminary examination with a certain time period in district court today. Do you understand that?
Yeah.
And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that?
Yes, sir.
And you, of course, are represented by Attorney Rico Neal today, and he would be present to contest any charges and cross-examine any witnesses brought against you. Do you understand that?
Yes, sir.
It's my understanding you wish to waive your right to preliminary examination and have this case go to circuit court where this is an unconditional waiver where negotiations will continue in circuit court. Is that correct?
Yes, sir.
Is it your wish today to waive your right to a preliminary examination?
Yes.
All right. I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. It is an unconditional waiver with negotiations to continue. And so your time in district court is done. Your next date in circuit court will come from your attorney, Mr. Neal, okay? All right, and then I'll have you sign the waiver of the preliminary examination. Let me just put the date in here. And I think there's a place for both of you to sign. Okay, that's okay. That's still got it. We know we got him. Thank you. All right, so the preliminary examination has been unconditionally waived. Sir, please keep in contact with your attorney, Mr. O'Neill, for your next date in circuit court. Your time in district court is done now, all right, sir?
Yes, sir.
All right, anything else for the record in docket 23-01881, Mr. Marshall?
No, Your Honor.
Mr. O'Neill?
Nothing further, Your Honor.
All right, thank you.
Thank you. Thank you, Your Honor, for the courtesy.
Yep. I think Miss Francis is out. Let's see what she's. All right, Ms. Francis, did you have the opportunity to speak with Mr. Winston or Miss Winston in a breakout room? We're back on the record in 2300913.
Good morning again, Your Honor. Sandra Francis on behalf of the plaintiff. I did have an opportunity to speak with Miss Winston, and there is no resolution, Your Honor. I would just ask that the
All right.
scheduling order be issued.
All right, I'm gonna go ahead, Miss Winston. I have a pretrial statement, and I'm gonna briefly go through that pretrial statement so that what I'll be looking for is just to set up some timelines in this, and then I'll ask for authorization for your understanding. If you want to see this, you can see this and authorize it. But you can also grant me authorization to sign on your behalf as we discuss it, and then I will sign it. But I will indicate for the record that this is the matter of portfolio recovery. Versus Yukia Love Winston. That is docket 23-00913 GC. Pretrial conference was held on today's date. And appearing was Miss Sandra Francis for the plaintiff. And for the defense, Miss, am I pronouncing your name right? Yukia
Love.
Kia Love, all right. Ms. Francis, what legal issue concerning this case is at hand? I have your complaint.
Whether the debt is owed to my client.
And Ms. Winston, I'm assuming you're objecting to that?
Yes, in my response, I asked for proof of invalidation of debt and
right.
original contract for the plaintiff, which I didn't receive.
All right. Do you indicate, other than the complaint and response, have there been any other pleadings filed?
No, Your Honor, not at this time.
And Ms. Winston, I'm assuming there's no, other than your response, there have been no other pleadings filed?
No.
Okay, Ms. Francis, I know this is early, but do you expect any motions or any dispositive motions, or are you holding that in reserve at this point?
We're going to be filing a motion for summary disposition, Your Honor.
Okay. And Ms. Winston, I'm assuming you'll be filing a response?
Yes.
All right. Do you have a time period, Ms. Francis, that you want that summary dispo to be heard by?
I'm sure we can get it out within the next couple of weeks, and then we need to give the defendant 28 days to respond. So,
all right. So let's do 60 days.
Yeah, 60 days should be sufficient.
To be careful. So September 20th falls on a Wednesday.
That's fine for us, Judge.
All right. I'm assuming at this point in time, there's no consolidation.
No.
Okay. Admissions of fact, it's too early. Exhibits the same, too early, within 14 days of trial. I would set it out for 90 days discovery. Does that sound about right? If depending on what happens with the motion for summary disposition?
That's fine, Judge.
All right. So the cutoff date for discovery would be October 20th. So Ms. Winston, just so you know, discovery is when both parties are providing information to the other side, and I've set the cutoff date for that for October 20th, 2023. All right, Ms. Winston?
Yes, thank you.
All right. The expert witnesses, I'm going to indicate too early at this time. I'll indicate within 14 days of jury trial or of trial. Damages the same. Same with joinder of claims. Has a jury trial fee been paid by either party, Ms. Francis?
No, Your Honor.
Yeah, I'm going to check the bench box. I'm going to indicate the possibility of settlement has been discussed. Do you see the need for evaluation or mediation in this case, Ms. Francis?
No, Your Honor.
All right, Ms. Winston, I'm assuming you since you're objecting to the nature of the debt, I'm assuming neither one of those would fit this case.
What are you asking? I'm sorry for.
Case evaluation would be whether more of a civil, more of a circuit court and possibility when it goes in front of a panel that evaluates the case. I don't see it as the nature in this district court, essentially a debt owed case. And then you may have a mediator look at this to see if you can negotiate something. And that doesn't seem to be the nature of this case. Would you agree with that, Ms. Winston?
Yes.
All right. So based on the pretrial statement that we've just filled out, the most important date is the discovery date, which is the cutoff on October 20th, 23, and the summary dispo motion to be filed and heard by September 20th. Ms. Francis, do I have authorization to sign this document on your behalf?
Yes, you do, Your Honor.
And Ms. Winston, do I have authorization to sign this document on your behalf? You'll get a copy of this so you can take a look at it. It's in my handwriting, so good luck with that. But do I have authorization by Zoom to sign this on your behalf?
Yes, Your Honor.
All right, I will also sign this document. And you have the dates, the pretrial statement will be mailed out to you. Anything else on 2300913, Ms. Francis?
No, thank you, Judge.
All right, Ms. Winston, you're all set. Do you have any questions of me?
No, thank you.
All right, you'll get a copy of this in the mail. Thank you, both of you, for your appearance today.
Thank you, Judge. Have a nice day.
You too.
Thank you. Bye-bye.
Mr. Marshall, we have some, I think they're Judge Buchanan's PCCs. Oh, we have Mr. Abbott too. How are you, Mr. Abbott?
I'm well, thank you.
Yes, Your Honor, if you could just bear with me slightly on that. I just found out this morning
All
as
right.
I arrived here that I was handling some of those, so I'm waiting to hear from Mr. Feigelson.
Okay, so that's Mr. Feigelson. We're all,
Yep,
you've got Feigelson and Mr. Austin on one and Feigelson on two. Were you ready to go on Miss O'Reilly?
Yes, Your Honor.
All right. Mr. Milks, were you?
We were hoping to do Wherewin.
Wherewin.
We had the sentencing this morning. I think I placed a few things on the record just regarding not being here.
Oh, all right. Let me put O'Reilly on first because I know O'Reilly. I know Mr. Abbott and Miss O'Reilly have been waiting through some of my civil stuff, and then we'll put that on next.
Thank you, Your Honor.
All right. So on the record in docket 2203192, that is People of the State of Michigan versus Courtney O'Reilly. Will the parties please indicate their appearances for the record?
Bob Marshall on behalf of the people.
Good morning, Your Honor. John Abbott representing Courtney O'Reilly. She's standing to my right.
All right, ma'am, you are Courtney O'Reilly?
I am.
All right, thank you. This is the time set. I think we set this because we were waiting on a report. Is that correct, Mr. Abbott?
Yes, and I have not received any. Other than from Miss O'Reilly herself, which is a very positive report.
So I have, and this was the last I heard on this case, on June 5th, 2023, which is prior to that. We were still waiting for the report. Miss O'Reilly remains on the admission wait list for competency restoration treatment per my dated order. I'm not sure yet. So that was the original, and then I have Mr. Abbott. Do you have that you're any violation of bond informational report on Miss O'Reilly?
No.
No, not yet.
No.
I have, as of April 21st, a report to the APA and Defense Council was submitted. That must be an old one.
Yeah, April. I thought you meant more recent, right?
Yeah, there's a March report and an April report, and we actually met back in June already, didn't we?
Yes.
All right. I just said pretrial review. She's here. All right, Miss Gunther. All right. So, Miss Gunther, you're here on Miss O'Reilly's case 22-03192.
Yes, Your Honor.
All right. So so we have to set this out again because we're waiting for the report. However, I've received some things, and I guess I wanted to take a look at that. I have a memorandum indicating that the defendant failed to report for drug and alcohol testing on March 23rd, 2023 and April 4th, 2023. And the defendant tested positive for THC on March 27th, 2023 and April 6th, 2023. That's a few months away. But is that the nature of the allegations that there were previous testing and testing positive and testing problems concerning Miss O'Reilly? Ms.
Yes,
Gunther?
Your Honor, that's correct. She has actually always tested positive for marijuana use. I have yet gotten a drug or alcohol test that was not positive for marijuana to some degree.
All right. Has she provided pretrial services with a card indicating that it's available to be used for any type of medical, or is it strictly recreational at this time?
I'm not sure. At this time, she has not provided any proof of medical marijuana use.
Okay, this is Ms. Gunther. Thank you, Nathaniel. All right. So when was the last test that Miss O'Reilly had?
She just completed one on the 14th that I'm waiting results for right now for the urine analysis. But the most recent urine analysis was on July 12th. That was still positive for marijuana. And then before that, it would be June 15th as well.
All right. All right. So we're waiting for a report, and we have some problem with testing concerning pretrial services. Mr. Abbott, your response to any allegation concerning that?
Thank you, Your Honor. Regarding the February and March and early April tests, we did have a hearing on those issues back on April 6th. Ms. O'Reilly was present in the courtroom, and we addressed those. I wasn't aware that there was any problem with the positive tests. She has been in constant contact with CMH and is working full-time at Peckham, maintaining a job there, maintaining a stable home, seeing her child on the weekends. And certainly, if you speak with her today, she's substantially improved compared to who she was when we first met her back in February. So I think she's, notwithstanding the positive marijuana test, she's certainly making progress on addressing the issues that got her in trouble, and she's keeping herself on the right path, and also communicating with the therapists and counselors that she needs to communicate with. Thank you.
All right. So Miss O'Reilly, you see the problem, right?
Yes, Your
Yeah.
Honor.
I mean, you're about 100% better than when you first walked in this courtroom. All right. And that, I mean, I don't have any letters after my name, but even I can see that. All right. So whatever you're doing is working, but we have a problem that you're testing positive. All right. It's a problem with pretrial services, and realistically, there's not been one test that you have not tested positive. Can we fix that?
Yes, Your Honor.
All right. I mean, are we able to fix that? And I understand that might be a form of self-medication of some level, on some level, but
I do have a question. If I'm
Sure.
able to get a medical card and provide that in the future, would that make any difference for?
as far as I'm concerned, yes. As far as I'm concerned, if you have a medical authorization and a card, then you and you're over 21. I'm willing to look at this as a medicine. All right.
But until then, I need to stop.
But until then, you've got it, and
Okay.
then that's how I treat this. All right. Ms. Gunther, I know we haven't had a discussion, so I don't know how you treat this, but that's essentially how I treat this. I will treat this as if she's able to get a card, but in the meantime, she's got to test negative, or else she's still under court order, and that's the problem we have. But I am familiar with Miss O'Reilly, and the fact that we're waiting has me have some issue in this, because we are waiting for you. So what I'm going to do today is we will revisit this issue under the next. It's going to take some time to get it out of your system.
Your Honor, I would also like to bring up that I no longer would like to be like on a waiting list to go into treatment, because I am now doing good with outpatient care and I have a full-time job. Right
I don't
now.
know. I don't know, Mr. Abbott, if once you filed it, can you withdraw the petition?
I don't know.
I could try.
All right. I mean,
I'm just like out there, like I don't want to be. If I can help it, I don't want to be on a waiting list because I'm doing good. That was like something that I put in like months and months ago.
it is, and we've
Yeah.
and
So things are different for me now.
Mr. Abbott, I'll leave that up to you. All right.
I'll petition to have.
Yeah. If
I can't imagine that they would object or so.
because they haven't done anything on it anyway. You know, they've literally have not done anything. So if they withdraw it, it may take longer to get the withdrawn done than to. But in this bureaucracy that we've created on some level, I'll leave that to Mr. Abbott. I'm going to reset this, so maybe we can just put this back on the docket and get it going. Ms. Gunther, did you have anything to add to anything I stated?
No, Your Honor, if there is approval for medical marijuana use, I would just request that an order be completed showing that the court is allowing it. At this point in time, it states no medical marijuana. Then I can follow that order.
I do not have a medical marijuana card as of right now.
Okay, sir, you got to stop.
Nothing to do with me,
Sir.
I don't know. It seems like this is so loud. I don't know if you can hear me.
Mr. Milks, is that your client?
No, it's mine.
Is your client? I don't know what to do with him. He's got a. Can he hear us? Mr. Milks, is it
Wilkins?
Mr. Wilkins? Mr. Wilkins? Mr. Wilkins? Mr. Wilkins? Mr. Wilkins? You got to stop talking until we're done with this hearing, okay? We can hear everything you're saying. All right, you're in a courtroom, and you got to stop talking until we're done with this hearing. All right. All right. Thank you. All right. The beauty of Zoom, my friends. So Ms. Gunther, that's absolutely correct. Until we get a card, you're still under the nature of testing positive for us. So let's fix that. So let's fix that problem. The bigger problem is, I do think that we need to withdraw this on some level, because you're doing really well. Whatever you're doing is working. But I want to make sure we don't lose track of this. So let's set it for another date. And then Ms. Gunther, I'll leave it to your, we'll set it out. I'll leave it to your, if you want to email me or email my staff as to how Ms. O'Reilly's doing while we're waiting. but the petition right now is to be I think the plan is to withdraw it, which shouldn't mean anything to forensics since they haven't done anything on our order to begin with now. But so I'm going to indicate who's here. All parties appeared, including pretrial services. And that is, have I been saying your name correctly? Ginther?
Ginther is correct, yes.
All right. Ms. Ginther from pretrial services. I'm going to give me about a 30-day out date if we have it. Yes, but none of that's been set. We don't have it yet. Okay. So
Making sure.
this is somewhere in the bureaucratic gray area.
Making sure. Is it okay if I go out to September just because
First week of September, I think would be okay.
Hold on.
So September 8th at 9 o'clock for a review. And at that time, we'll revisit your petition for forensic and then how you're doing, as we talked about with your testing positive. And we'll also review if you're able to get a card, okay, before then. All right, anything else for the record in docket 2203192, Mr. Abbott?
Oh, thank you.
Ms. Gunther, do you have anything?
No, thank you, Your Honor.
All right, Ms. O'Reilly, whatever you're doing is working, okay? You're doing really well. So hopefully on September 8th, we'll have this somewhat figured out, okay, ma'am?
All right.
All right, thank you. Thanks. We're all set on that file. Thank you for your parents, Ms. Gunther.
Thank you, Your Honor.
All right, so we're on the record in docket 2203572. That's People of the State of Michigan versus David Werwin. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
Morning, Your Honor. Stephen Milks on behalf of Mr. Werwin, who was not present with us at the time. Today's the date and time scheduled for sentencing, I believe.
All right. All right, Mr. Stevens, how are we proceeding today?
Your Honor, I will defer to Mr. Milks. I know there's been some email exchanges. I'm certainly aware of them.
Okay.
As the court can see, Mr. Werwin's not present. The court may already have a preview as to why. So with that, I'll defer to Mr. Milks.
All right, Mr. Milks.
Thank you, Your Honor. Your Honor, currently my client is in McLaren Hospital. I believe that the hospital did PRT him. I found this out from Ms. Jane Jakeway, who is the complaining witness in this matter. She's been contacting my office and updating me regarding his status. At this time, Your Honor, I found this out. This was, I think, a day or two ago. And I did get an email from the court asking that we have some sort of documentation or some sort of record regarding hospitalization. Unfortunately, I do not have a waiver for McLaren Hospital. I've got it for a different hospital, and we would not be able to get documentation of that so far. This has happened previously in the past where he has to be hospitalized, Your Honor. He is 77 years old and has known mental health issues, I guess. Simplest way to put that.
So it's your understanding, Mr. Milks, that he is at this time at Sparrow St. Lawrence as a person requiring treatment, but we don't have any confirmation of that because of the rules.
Yeah, McLaren, I believe, is what Ms. Jakeway informed me of. He's in their behavioral unit. And yes, that is otherwise correct, Your Honor.
All right, because I have Sparrow as of March 16th.
That was his previous.
All right,
probation.
so this is new.
It then, which is also why I don't have a release of information.
I would just add, Judge, and I don't know that you would necessarily know this, but the parties, Mr. Milks and I would know this. The complaining witness has been incredibly helpful in sort of reporting when he is or is not in hospitals. I think there was in the past, I don't know if we made the change or not, to allow her to have some limited contact so we could address his hospitalizations both in the past and probably ongoing. So when Mr. Milks indicates that she reported to him that Mr. Rearwind's in the hospital, I have a tendency to believe that.
Right. Well, and that, if we're talking about, that's the complaining victim, Ms.
Correct.
Which we have, who's been involved in this case, and this is this case. So we don't have an out date.
Correct.
And so is your request today to adjourn the sentencing?
It is to adjourn the sentencing, Your Honor. What Ms. Jakely did provide me is that she believes it will be like roughly 4 days or so. I specifically remember asking her, will he be able to get out by today's date by court? Because this was a few days ago. She said no, that wouldn't be happening. And I'm just going on what she has informed us about.
Mr. Milks, do you have any objection to of course, the adjournment? I don't think you're seeking a bench warrant in this, or
people have no objection to the request for an adjournment, and I'm not seeking a bench warrant. Like I said, I was aware of sort of the email correspondence that led into this. And so when he's not here this morning, that was anticipated. So Mr. Milks, I'm kind of leave it in your ballpark as to a good sentencing date. Because I want to make sure, first of all, I understand the relationship between Ms. Jakely and your client, but I want to make sure he's out, and I want to make sure he's available for sentencing, and you're able to spend time and go through, whatever you need to go through with him. But I don't want to set it at a time. So you let me, what do you think?
Yeah, I appreciate that, Your Honor. Thank you. Your Honor, based on Ms. Jakely's statements, I'd ask that maybe we set it up for 2 weeks. Part of my concern is that with a lingering sentencing date, it may have some effect on his anxiety, which could be leading into some of this, or having breakdowns.
So he'll be back in a hospital again.
If we get it fast enough, hopefully we'll take care of this other issue.
So do we have time on the first week of August? Okay. Because we could do it the third? No? Okay. Oh, I'm not here. That's the Ingham County Bar Association golf outing.
Oh. That's fair.
So, and since I am a host of that, I probably should be there. Not because of my prowess on the course, but because I'm hosting that, and you should show up for things like that.
How about 8:30 on August 4th?
Okay, 8:30 on August 4th. Does that work?
I've got a preliminary examination scheduled that morning. What about the following week? Maybe the 10th. It's a Thursday.
10th. Will that work?
8:30.
8:30 on the 10th.
Perfect.
All right. At 8:30. All right, so we've adjourned the sentencing to August 10th at 8:30. If anything comes up, let the court know. Anything else for the record on 22-03572, Mr. Stevens?
Thank you.
Okay. Mr. Milks?
One very small matter, Your Honor. There's been some discussions about my client possibly getting a mental health treatment court or veterans court. The defense is not seeking that. I just want to place on the record right now. I know that has been a discussion.
All right.
There's been some confusion about that, but we are looking to go forward just with a regular sentencing. I believe we're requesting 7694A.
All right. All right.
Otherwise, nothing further.
All right. Thank you.
Thank you so much. Appreciate it.
No, I'm.
You ready on Mr. Delgado?
Yes, we are. Yeah, it's sort of a windy path.
Should do one of these pieces.
and
One of these.
Oh, that was it.
Yeah, and I should be good with Buchanan.
All right, so we're on the record in docket 23-02136. This is a probable cause conference on Carlos Delgado. This is in front of Judge Buchanan. Parties' appearances for the record.
Bob Marshall, on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Carlos Delgado, who's on polycom from the Lincoln County Jail this morning, Your Honor.
And sir, you are Carlos Delgado?
Yes, sir.
And you can hear me all right, Mr. Delgado?
Yes, sir.
All right. This is time set for probable cause conference. Mr. Marshall, how are we proceeding today?
I would defer to Mr. Feigelson, Your Honor.
Mr. Feigelson?
Judge, two things. We do wish to leave the matter on for an exam, but Mr. Delgado, when I met with him yesterday, advised me he's seeking to retain his own counsel. This, I believe, he's working on getting that. I asked that we either waive the 21 days today or the matter set for an exam next week. And if counsel comes in at that point, we could.
Okay. So we'll leave on for preliminary examination with the understanding that today he is seeking to retain his own counsel.
That's correct, Your Honor. If the court's inclined, we can do the 21-day waiver today.
Yep, I am, and we can. No, we're leaving it on for prelim, but we are waiving the 21-day rule. Yeah. It's only for his. Don't worry about it. So we're leaving on for preliminary examination on next week's date, which would be the 27th. Is that correct?
If we're gonna waive the 20 days, can we get another exam date, or do you want me to treat that as a PCC?
What I want you to do, since it's not my file,
Right.
I want to waive. If you're asking for the waiver of the 21-day, I'm more than willing to do it.
Right.
But you should set it for prelim date on 27th, so Judge Buchanan can make sure he's seeking other counsel and actually retaining other counsel. That's my fear. My fear is, to say it is one thing, but actually do it as another.
Let's wait to put a date next week.
All right. Okay. So you just want to wait to do the whole thing next week?
Yes, right. Yeah.
Okay. All right. So we'll leave on for preliminary examination on July 27th, 2023. D is, and I'd make a note that D is seeking to retain counsel, and then we'll go from there. All right, so Mr. Delgado, please keep in contact with your current attorney of record, Mr. Feigelson. It's my understanding you're seeking to retain counsel, and we're leaving this on for prelim for next week, which is July 27th, 2023. All right, sir?
Yes, sir.
All right. Anything else for the record? 23-02136, Mr. Marshall.
No, Your Honor.
All right, Mr. Feigelson.
No, Your Honor. Thank you very much.
Thank you. We're all set. Mr. Abbott, did you want to go on Mr. All right, Mr. Wilkins, we're ready to call your case. We're here on docket 23-00672. That's People of the State of Michigan versus Gerald Wilkins. Will the parties please introduce themselves for the record?
Bob Marshall, on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Gerald Wilkins. He's appearing today by video from the jail.
And sir, you are Gerald Wilkins?
Yes, sir.
Okay, and you can hear me all right, Mr. Wilkins?
You said what?
Okay, this is the time set for a preliminary examination. What's that? Just a PCC? All right. So from the people, how are we proceeding?
Your Honor, I believe that we are just leaving this set for preliminary exam next week while we continue negotiations.
Okay. Is that your understanding, Mr. Abbott?
It is, Your Honor. The people have made an offer of a misdemeanor here, which I have not had a chance to speak with Mr. Wilkins about yet. There's some question as to whether the stuff they found on him was actually really cocaine or not. I'm not sure if we're going to wait for the lab results or not.
And the prelim is set for the 27th, is that correct, or the
27th?
Okay. All right, so counsel may inquire of your client to make sure he knows what we're doing today.
Yes.
Mr. Wilkins, you understand this is set for probable cause conference today. An offer's been made, a misdemeanor offer's been made. We're leaving it on for preliminary examination for next week on July 27th of 2023. Well, you'll have some time to consider the offer and the attorney will talk to you. Mr. Abbott will talk to you. All right, sir? All right. Anything else on the record in 23-00672 from the people?
No, Your Honor.
Mr. Abbott?
Your Honor, the issue of bond currently set at $100 cash, which is exactly $100 more than he has. He's right on the edge of getting his Section 8 housing set up, and if he could get out and maintain communication with the VA and the people that are helping with that, it really improve his chances of success in life in general. So I'd ask the court to consider reducing it to personal recognizance in light of the fact that we're very likely to resolve it one way or the other into a misdemeanor soon.
All right, response.
Your Honor, I believe that's a pretty fair bond in this matter. I would ask that it be left set at least until the preliminary exam and we know for sure that a plea can be had.
All right, with an understanding that this is an habitual fourth notice. I think this is an habitual fourth notice concerning R&Os and previous felonies. It's a fairly 100 cash surety is a fairly low bond for that. This is a possession of cocaine case. So, but I'm going to leave bond as is, and we can revisit it at the preliminary examination.
Okay, thank you, Ron.
Thank you. All right, so that's all on the record. 23-00672. Mr. Wilkins, we'll see you next week. All right, sir.
No.
Thank you, Ron. Thank you. And Mr. Wilkins, you're free to leave the Zoom courtroom. Thank you for your appearance. Sir, with the moniker Skunkiest Beard, would you please identify yourself?
Your Honor, that's his name.
His name? Is that a witness?
No, I've prosecuted him before. That is his name. It's Chunkiest with an H.
Chunkiest. Sir, Mr. Beard, what case are you here on? Mr. Beard, what case are you here on? Mr. Beard, what case are you here on? You're not on either one of my dockets. Okay. So we're on the record in docket 23-01966 and 23-01965. That is people of the state of Michigan. 66 is people of the state of Michigan versus Andrew Stalins, and 65 is people of the state of Michigan versus Tammy Lynn Larkin. There are co-defendants in this matter. Will the parties please introduce themselves for the record?
Bob Marshall on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson standing in and representing Mr. Stallings, Your Honor. Ms. Larkin does not have counsel yet. Our office obviously cannot represent both. I think we're in the
Right.
process.
So let's do Mr. Stallings first. So, sir, you are Andrew Stallings?
Stalins.
Stalins? Okay, thank you. This is the time set for a probable cause conference. Mr. Marshall, how we proceed?
I would defer to Mr. Feigelson.
Okay, thank you.
Your Honor, there's been an offer that Ms. McVeigh or Ms. McRae, I had my tongue tied, Ms. McRae conveyed to myself, and I've talked to Mr. Stallings. I do believe he's amenable to accepting that plea offer. I don't know if the court wants to do that today or return next week with regards to that.
I will leave that. What is the offer?
It's going to be an attempt to the charge, the 1-year misdemeanor with no objection to the defense asking for height and that people will consent.
I don't, so Mr. Marshall, you probably don't know anything about this case.
I don't, and I don't even have a e-docket from.
So let's leave it on for next week. So
Yeah.
I think that's the fairest thing to do. Because I'm going to indicate that the PCC held, the offer was made. The offer is an attempt, which is a 1 year in this, I think.
Yeah, that's correct, Your Honor.
And then we'll leave on for preliminary examination, which will allow, I think that's fair to let the prosecutor some time, who knows about the case. This is there may be some restitution in this matter. I don't know.
Right.
So, so we'll leave on for preliminary examination in front of Judge Buchanan for July 27th. All right, so Mr. Stalins, please keep in contact with your attorney, Mr. Feigelson. I've just left it on for prelim next week, all right? And then you can discuss the nature of the plea offer, okay? All right. So anything else for the record in 23-01966, Mr. Marshall?
Nothing from the people, Your Honor.
Mr. Feigelson?
Nothing on behalf of the defense, Your Honor.
All right, and then, okay, so Mr. Stalins, you'll be in front of Judge Buchanan next week at this time, all right? All right. And then Ms. Larkin, you are not represented today, but we're going to call your case. And my understanding is they're seeking conflict counsel for you.
Yeah, I believe that's correct. Your Honor. I think we
All
should
right.
fill out an application. I do believe she's going to qualify. It's just
All right.
finding a conflict counsel to accept it.
Okay, so the PCC was held, looking for conflict counsel.
We'll provide.
So let's do appearances for the record on 23-01965, Mr. Marshall.
Bob Marshall on behalf of the people, Your Honor.
And ma'am, you are Tammy Lynn Larkin?
Yes, my last name is actually Horn.
Horn? Horn?
Yes.
I'm going to put that in parentheses, and then we might have to change the complaint, because the complaint, I think, is still in Larkin, okay?
Yes, it is.
All right, and it's my understanding that you are seeking conflict counsel concerning this file. Is that correct?
Yes, I am.
So I'm going to leave this on for preliminary examination for next week in front of Judge Buchanan, so that A, you can get an attorney to look at this case, and B, you'll also your co-defendant, and they put his case on for preliminary examination next week also. Okay.
Yes,
Do you have any questions of me, Ms. Larkin?
No, sir.
All right. So I'm going to indicate that left on for prelim exam or PE. Do we have a time for that?
Or
Yeah. Because I'm just all I've said is it's on the 27th, but I haven't given 10 a.m. All right. So they've set it for 10 a.m. for next week. So be in front of Judge Buchanan at 10 a.m. next week. All right.
Yes, sir.
You may hear from conflict counsel before that, but you're responsible for that date. All right.
Yes, sir.
Anything else on 23-01965, Mr. Marshall?
No, Your Honor.
All right, Ms. Larkin, you're all set. Thank you for your
Thank
time.
you, sir.
Have a nice day. We'll see you.
You too, Mr. Feigelson. Thank you.
Judge. That guy's back in the waiting room again.
Well, let's get done with what we need to get done, and then we can address
Just
it.
wondering if he's using somebody else's device and it's somebody that's actually not.
Oh, yeah, that's a very good point. You're forcing me to admit him again, okay? Because you made a good point.
Excuse me.
Sir, are you Mr. Beard or somebody else?
I'm Jones, but it just says Beard. Yeah.
Is that Malachi Jones? Yes.
Is that so? You're Malachi Jones, is that
Yes,
correct?
Sir. Yes, sir.
All right. Let's change your moniker because you're coming up as Chunky as Beard, and then we're having trouble talking. But you are Malachi Jones, and your attorney is Mr. Abbott. Is that correct?
Yes, sir. Yes, sir.
All right. Mr. Abbott, are you ready to proceed on Mr. Jones?
Yes, Your Honor.
All right.
Good morning.
So your attorney is here, Mr. Jones, and we're ready to go forward on your. This is just a probable cause conference. The preliminary examination is set in front of myself next week. So appearances for the record.
Marshall, on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Malachi Jones, who appears by Zoom.
And sir, you are Malachi Jones, is that correct?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Jones?
Yes, sir. I can.
All right. This is the time set for a probable cause conference. Mr. Marshall, how are we proceeding?
I would defer to Mr. Abbott.
Your Honor, we'll just leave this on for a preliminary exam next week.
All right.
And there may be some negotiations between now and then.
So we'll leave on for preliminary examination for July 27th at what time? Yeah,
Is that 8:30?
Thank you, Malachi.
All right, Mr. Jones, you are correct. We're going to leave this on for preliminary examination on July 27th at 8:30. That would be live, so make sure you're here on the 6th floor and on that date, on that July 27th date at 8:30. All right, Mr. Jones?
Yes, sir.
All right. Anything else for the record in docket 23-02-108, Mr. Marshall?
No, Your Honor.
Mr. Abbott?
No, thank you.
All right. Mr. Jones, we're all set. We'll see you next week at 8:30. Okay, sir?
Okay.
All right. You're free to leave the Zoom courtroom. Thank you for your appearance today.
Thanks, Uncle. It's nice to see that he actually exists.
He does. And he is not. We're on the record in docket 22-01288. That is People of the State of Michigan versus Sharita Walters. Will the parties please introduce themselves for the record?
Marshall, on behalf of the people.
And good morning, Your Honor. Jared Austin appearing on behalf of and in the absence of Ms. Walters.
All right. This is the time set for a review of, we received about 2 or 3 weeks ago, a competency report, an incompetency report, that the D was currently incompetent from the Forensic Center. This case has a long history. So Mr. Austin, I'll defer to you to indicate what your understanding is. And then Mr. Marshall, we can talk about a good date for us. So Mr. Austin.
Yes, Your Honor. Thank you. The court is aware this case has been pending for quite some time. I originally filed my motion for competency evaluation and criminal responsibility. Ms. Walters was found to be not competent, but it indicated that she could be restored to competency. And then we went through a period of time where she was not being transferred for the necessary treatment as the court ordered. There was a show cause for the Forensic Center when, and shortly before that, they said they found space and that she was being given the treatment that she was needed for the competency issue. It doesn't appear that there's been much progress or subsequent reports regarding the competency issue. The reports that we have gotten have all indicated that she still is not competent to proceed to trial. And it indicates that I think at a minimum, no progress towards that competency has been made. If nothing else, it may even sound like she's even degressed in that arena. So it at least at this point, it doesn't appear that she's on the track to be restored to competency. When we were here last, the court asked me to look into the issue of what kind of time frame and timeline we're looking at as to how long this can linger on before some other action needs to be taken. I researched the issue and filed a memorandum of law, which I filed with the court, and as well served a copy on that on the people. The 15-month time period under the law, I think, is what is applicable here. I think what triggers that is the original date that Ms. Walters was deemed to be not competent to proceed to trial, which I believe was in August. That 15-month time period would be set to expire around the very end of November of this year. And at that point, if she is still not competent to proceed to trial, the remedy would be that the case be dismissed and that the people could seek civil confinement at that point. And I have just asked for a review hearing around that date and time to see what progress, if any, has been made towards restoring Ms. Walters' competency. And if it appears at that time that she is still not competent to proceed, I would be asking the court to dismiss the matter at that point as the law directs, and then it would be up to the people to seek civil confinement.
All right. And so with that understanding, and we've had brief discussions concerning this matter, Mr. Marshall, some of this was just bringing you up to speed. This is a new file for you. We've reset the review for November 2nd, 2023 at 8:30. And that would be prior to, but in the same month of the actually addressing whether the defendant's been able to reach competency within the statutory time limit of 15 months. And so, Mr. Marshall, that would put you on notice that if something's not done by then, if the defendant has not reached competency, then a civil petition probably is in order, and you can do whatever it takes for that in that regard.
Yes, Your Honor, the court and Mr. Austin has done a great job filling me in on what's been going on as I'm just stepping in on this file. I believe that the November 2nd date would be great as a adjourn date and another review. That would give us plenty of time before the I believe it was the 26th.
Or the 29th, I think, according to the court.
Yeah, I think it's the 29th. Yeah.
That will give us plenty of time for me to get with the individual in my office that would handle that petition.
All right, perfect. All right, so we have a plan, gentlemen. We will look to see in November 2nd if competency is reached and any review in that regard. Mr. Austin, if you hear anything along those lines, let me know. Or if you have if you have an indication that that date is just a futile date on some point, maybe we'll address this sooner. But we'll reset it for November 2nd at 8:30, and we'll go from there. Anything else for the record in 22-01288, Mr. Marshall?
No, Your Honor.
Mr. Austin?
Nothing additional, Your Honor.
All right, thank you. And thank you for doing the memorandum of law and doing some research on this. I appreciate that.
Certainly.
All right, that's all for the record on that file. Thank you for your appearance.
Thank you, Judge.
Michael Mayberry, also FT8 on Tuesday for his PBA. I think you signed his bench warrant, but it hasn't been entered yet.
Okay.
He appeared downstairs. Do you just want to reset it, or do you want to read it?
This is reset.
And
Mr. Abbott, do you have the rest of the docket?
Boy,
I'm sorry, I'm not ignoring you.
Carl Knox, Your Honor. He's ready to go. We're gonna run a preliminary exam.
All right, and Mr. Washburn on Brittany, I've also got a Brittany Washburn for competency hearing.
I emailed you last.
What's that? I don't know where she is not here, I think.
she might be downstairs on a writ. I don't know.
Oh, there is a writ on her.
Yeah, I haven't seen her in a long time.
She's been. Let's see. I have an order finding that she's competent to stand trial.
Yeah.
All right. And I have an order to that effect. All right. So you probably, which one do you, let's do Knox first, and then we can always bring her up. Because she's not going anywhere, I don't think, off her writ. Yeah. Neither one of, but you guys, because where's she writ?
Should be here from Clinton County.
All right. So get Knox first. We'll do that prelim, and then we'll go from there. All right. We'll take a mid-morning break, and Daniel go grab Mr. Abbott's claim.
Oh, I'm all set. It's just a two-person preliminary exam. So when you got
23-01800, people of the state of Michigan versus Carl Knox. Will the parties please introduce themselves for the record?
Bob Marshall on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Carl Knox. He's seated to my right.
And sir, you are Carl M. Knox? Yes. All right, this is the time set for a preliminary examination today. Mr. Marshall, how are we proceeding?
Your Honor, the defendant has elected to run the preliminary exam.
Are there any preliminary matters to come to the court's attention before we start the hearing?
Your Honor, just briefly, possibly, I'm unsure how the court does this. I do have a document that I would like to submit under the business record exception, if you'd like me to do that at the end of testimony or as a preliminary matter.
We'll wait until you lay foundation for it and we'll go from there. Okay,
Understood.
Fair enough, Mr. Abbott.
Thank you.
All right. So preliminary examination will be run. I'm going to leave it. I'm going to sequester witnesses. There's nobody in the courtroom, but you guys know the file better than I do. So if anybody walks in that you want me to address the sequestration, we'll address it at that time. All right, Mr. Marshall?
Understood, Your Honor.
Mr. Abbott?
Yes, thank you.
All right. With that understanding, Mr. Marshall, you may call your first witness.
Your Honor, I am going to grab her from the hallway.
Okay. All right, ma'am, I'll have you come right in front of me. You're gonna have to stand right here, and I'm gonna have you state your full name and spell both your first name and last name for the record and for the court reporter.
Tressa Burning. K-A-T-R-E-S-S-A.
Tressa, okay.
Burning, B-E-R-N-I-N-G.
All right, thank you. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay, go ahead and have a seat. Go ahead and have a seat here. You're a little soft spoken, so I'm gonna have you speak right into that microphone, okay? And that way the court reporter can hear you, okay? Because that's for recording purposes. Try your best to project to the back of the room, all right?
Okay.
All right. Mr. Marshall, when you're ready.
Good morning, Ms. Burning. I'd like to start by drawing your attention. I know it's a while back, November 9th, 2021. Do you remember that date?
Yes.
And on
You
that
can't
date,
hear her. So ma'am, you should move right up to the audio because we're having trouble hearing.
Yes, I do.
You hear that? Go ahead, ma'am. Go ahead, Mr. Marshall.
thank you, Your Honor. So on that date, were you at the Dollar General on South Waverly?
Yes. Yes.
Is that in the city of Lansing, county of Hingham?
Yes.
State of Michigan? And while you were at Dollar General that day, did something happen that lead you to contact police?
Yes.
Can you explain to me about what happened?
Me and my daughter pulled up to Dollar General. And we didn't realize that he was sitting in the car next where we pulled up.
When you say he, who do you mean?
Carl Knox.
And do you know Carl Knox from previous encounters?
Yes.
How?
My daughter, that's my daughter's or my grandbaby's nephew, first uncle.
And do you see him sitting in the courtroom today?
Yes, I do.
Can you describe something he is wearing?
His handcuffs.
The color of his
blue, dark blue.
Your Honor, I would ask that the court, that the record reflect that the witness identified the defendant today.
Mr. Abbott, any objection to the witness identifying the defendant for preliminary examination purposes?
No objection.
Without objection, the witness has identified the defendant.
If you may proceed telling me about what happened at that day.
We pulled up and we parked the car. She was getting ready to go in, and we look over and we saw him. We're like, oh, great. Then he gets out of his car and walks over to my window, pulls out a gun and points it at my head on the glass.
When you say he pulled out a gun, where did he pull that gun? He was walking to your window. Could you see that gun at first, or
No.
was that concealed?
No.
And So then you stated that he pointed the gun at you?
Yes, at my head.
And did he say anything when he did
Said, I
that?
will kill you.
And at that point in time, what were you thinking?
And he was gonna kill me. Then he walked over to my daughter's window and pointed the gun at her, to her head, and said the same.
What did he say when he did that?
I will kill you, MF.
And what did you do at that time?
I was dialing 911.
And did you waited there for them?
He ran and got in his car and took off.
Do you remember anything about the gun?
It was smaller gun.
You know, color?
Black.
Black. So how long would you say this whole encounter lasted?
Maybe 3 to 5 minutes.
So as he walks up, he points the gun, says, I'm gonna kill you, then walks around.
Yes.
That's the sequence that, you know,
Yes.
and then he just left.
Sped off it quickly. Went straight out of Family Dollar to the street across.
Where did you see where he placed the gun when he walked away? Your Honor, the people would move people's proposed exhibit 1 under the business records exception. It is a certified copy of conviction of a prior felony in this.
All right, motion to admit People's Exhibit 1 as a certified prior conviction, Mr. Abbott.
I see that it is a certified document.
So under the self-authenticating document rule, I'll allow it so that the exhibit's admitted.
Your Honor, may I approach?
You may.
Thank you.
All right. Thank you, sir. And you may continue questioning, or I can make the witness available for cross-examination.
Your Honor, I believe that the people have completed their questioning.
All right, cross-examination, Mr. Abbott.
Thank you. Good morning. So did you know Mr. Knox before that day?
Yes.
So if they wrote in the police report that you told them you didn't know him, that was a mistake?
It had to be a mistake because he is my grandbaby uncle.
And you're sure it was him that day?
I'm positive.
Doesn't he have a brother?
Yes, he does.
You can tell them apart?
Yes.
And the gun, you said it's a handgun?
Yes.
You know what caliber it was?
No, who wouldn't know that?
All right, so he left immediately. Was he in a car?
Yes.
And that car was parked there when you got there?
Yes.
You parked next to it?
Yes, I'm not realizing that it was him.
You didn't recognize his car?
No, I didn't know he had a car.
So you know him, but you didn't know if he had a car or not?
No, because I don't really deal with him. I mean, I hadn't seen him in a minute.
And by a minute, you mean several months?
Yeah.
So he left in a car. What do you know what kind of car it was?
A smaller black car.
Okay. Did you see the license number?
I don't remember.
You don't remember it today?
No.
And Other than the person in the car with you, was there any other witnesses?
No.
And have you seen him since then?
No.
And prior to that date, do you remember when the last time you saw him was?
No.
So we haven't seen him since November of 2021?
Yes, I have not.
Were you aware of any of the other legal problems people in his family may be having?
Yes.
Objection, relevance.
Response?
I guess I'll withdraw the question at this point.
All right, thank you. The objection sustained.
No questions further, thank you.
All right, redirect it, Mr. Marshall.
No, Your Honor.
And ma'am, you are, just for my edification, your Katressa burning, are you Katressa M burning or Katressa B burning?
M.
Your Katressa M burning. All right, thank you. Without objection, may this witness be excused from the people?
Yes, Your Honor.
From the defense?
Yes.
All right, you're excused, ma'am. Thank you for your appearance today. And Mr. Marshall, you may call your next witness.
Your Honor, may I step out to?
Sure, yeah.
Your Honor, may I approach briefly?
Yes, you may approach.
There was an issue with a minor child, so I think that
All right.
this point,
So,
I'm gonna let- I'm
so
gonna
that,
release her.
all right. So that's Katrina B. burning, correct?
Her last name is Chambers, the other.
Chambers. All right. I'm assuming that you'll just listen to the arguments that are made for bind-over.
I guess I'll have to.
Right.
And, Your Honor, that was my next question. Each court does
Right.
it differently.
You can ask for an adjournment to get her back, or you can make your motion.
No, I just wasn't sure. Judge Hillman does not require you. He just asks that it be bound over. He doesn't require facts on the record.
Oh.
Or Judge Allen has you lay the facts out.
I usually lay the facts. It's
You got
it's
it.
your motion for bind
Yep,
over.
you got it.
All right. So with that understanding, do the people rest at this time?
Yes, Your Honor.
All right. Mr. Abbott, any proofs today?
Not today.
All right, thank you. Motion for bind over, Mr. Marshall.
Your Honor, the people would request that this court bind over on the charges in the complaint after the testimony that was heard today. The court heard testimony from the victim, Katressa Burning in this matter, who testified that at the Dollar General, which is in the proper venue of this court, the defendant, who she was able to identify as Mr. Knox, approached her vehicle and removed a firearm that she originally could not see, which was concealed in his waistband, removed that, walked up to her window and pointed it it directly at her head and made threats to kill her. The defendant, she testified that the defendant then walked to the other side of the vehicle and pointed it directly at her daughter's head and made the same threats. While she was calling 911, the defendant then fled the scene. It's clear based on that testimony that the people have met the burden for count 1 or count 2, carrying concealed, count 3, assault with a dangerous weapon. There's no question that a gun, a handgun, is a dangerous weapon. And count 4, which is on her daughter. The people also believe that we've met our burden for count 1, possession by a felon. I did submit people's proposed exhibit 1, which is a certified prior conviction for carrying a concealed weapon. Thank you.
Response, Mr. Abbott.
Your Honor, under these circumstances where there's no corroborating witnesses and there's no video and other evidence, I'll leave it to the court's discretion for bind over.
So the court finds that the preliminary examination standard, of course, is probable cause being one of the lower standards in criminal law. I find by probable cause evidence, location, venue, ID, and date have been made at a probable cause standard. The location being 3520 South Waverly in the city of Lansing, which is the venue, 54A, Ingham County, date of November 9th, 2021, I believe, have been proven by probable cause evidence. The witness was Katressa Burning, and she indicated that on that date, the defendant, who she ID'd in court, walked up to her. She did not see a weapon on his person at the time, so it must have been concealed at the time, but then did put a gun to her head while she was in a motor vehicle, I believe, but put a gun to her and indicated that he was going to kill her. She indicated then he went to her daughter, who was also in the motor vehicle, and that is the Katressa Chambers, and indicated to that person all the same, with a gun in hand, that he intended to kill her, using some expletive after that. So I find at a probable cause level that counts 2, 3, and 4 are bound over to circuit court in the motion for bind over, as location, offense, venue, ID, and date have been made in regards to the count 2 of CCW, count 3 of assault with a dangerous weapon upon the person of Katressa Burning, and count 4 assault with a dangerous weapon in regards to Katressa Chambers. As to count 1, the people provided a document, People's Exhibit 1, indicating of a felon in possession, in that the individual who is charged with, pursuant to eyewitness testimony, being possession of a gun, did possess a firearm when ineligible to do so because of the imprisonment requirements. The prior conviction is set for at least beginning in 2015 and then ending well after that time period. So I believe count 1 has been proven at a probable cause standard. So the court will bind over counts 1, 2, 3, and 4 to circuit court based on the testimony of the witness and the exhibit. So Mr. Knox, your time is done in district court. You're bound over to circuit court, where you'll get your next date from Mr. Abbott, who is your attorney in the case. So in circuit court, you'll get your next date from Mr. Abbott. Your time in district court is done. And I will indicate for the record that the preliminary examination was held on July 20th, 2023, and probable cause exists to bind over. And it is as charged in the complaint. Anything else for the record, Mr. Marshall, on docket 2301800?
No, Your Honor.
Anything else, Mr. Abbott? Well, thank you, Your Honor.
All right, Mr. Knox, your next date will come from your attorney, Mr. Abbott. You're all set in district court. Thank you for your appearance, sir. And Mr. Marshall, I'll return your exhibit to you.
I thank you, Your Honor. May I approach?
You may. All set, Mr. Abbott?
Yeah, thank you.
And then we have Miss Washburn. You probably need a second to talk to Miss Washburn.
She's not here.
She's not here.
She's not here? I didn't know that.
She did not get.
She did not get
writ.
brought on the writ for some unknown reason.
All right, well, let's go ahead and put that on the record, since we can. So we don't know, she's coming from Clinton County, right?
We hope.
So we're on the record in docket 22-03252. That is People of the State of Michigan versus Brittany Washburn. Will the parties please introduce themselves for the record?
Marshall, on behalf of the people.
Good morning, Your Honor. John Abbott representing Ms. Washburn. She's not present today. I think she's in custody in Clinton County.
That's my understanding. She was to be writ over for a forensics review concerning her this competency hearing. We did receive a report. There is an order in the file. However, we can't go forward without Ms. Washburn. And for whatever reason, she was not writ over on today's date at today's time. So my indication is that we will adjourn the matter and reset it.
Please, soon as
That's
possible.
fine with me, Your Honor.
All right, yes.
The court rules under Chief Judges. The competency has to be held within 5 to 7 days unless both parties waive on the record to be closed.
All right, so just so we can set a date, we can do it within a week. We can set it for next week. We can't do a writ, can we?
Yeah, therein lies the problem.
All right. Well, we could try, but for our purposes, do the people waive? We have to have a review hearing within 5 to 7 days of the July 10th, which would be today's date. We're already outside of the date.
The date we received it.
What date did we receive this?
It should be received somewhere in the arms.
You'd like to think so. You sure can.
I got it.
Mm-hmm.
Looks like we received it in our office on the 13th, Your Honor.
All right, so we have till today's date, unless it's waived on the record, so that we can set it for some date and writ her out in a timely fashion, which we did, and then she's not here. I think any time frame can be. So I assume there's no objection from the people.
No, Your Honor, and I believe I don't know how quickly the court can do a writ, but
Right.
if they can do it next week, I think Jeff will be back as well, so.
Right, it would be done as quickly as possible. The only problem is it would be next week. It would be the first week of August. We'd have to fit it in someplace. So I could adjourn for good cause. I think it's good cause that the defendant should be here and should be addressing, but it may not be good cause that the writ wasn't fulfilled. I'm uncertain about that.
Regardless, Your Honor, I understand it's impossible to hold a hearing today.
Right.
To meet the deadline set by the statute.
All right.
People would agree.
All right, so with that understanding, we are going to reset the competency hearing because we don't have the defendant, and we'll reset the competency hearing for as soon as possible after a writ can be done. And I don't expect a long, well, it's up to you guys, but as far as the competency hearing is fairly straightforward.
Yeah, we'll admit to the admission of the
Right.
report. It looks like they found her
So
competent.
we don't need a lot of time for it. We got to find a place for it.
Mr. Abbott, would you be available on Tuesday, August 1st by chance?
No.
Okay.
That will be my first day in this courtroom.
Was it?
Yep.
Okay.
Would you be available on August 4th, which is a Friday?
I can find someone to cover this hearing. I'm going to be gone the last week of July and the first week of, the last week of August and the first of September. So I will be here.
On August 4th?
On August 4th or 1st. I apologize.
Oh, we can.
Which would the court prefer?
Doesn't matter. Which works better for your schedule, Mr. Abbott? August 1st or August 4th?
They never.
I know where you're going to
I'm
be.
surprised.
Yeah. I don't always know where Mr. Abbott's going to be.
Well, Friday, I'll definitely be here on the 4th.
All right. So let's do August 4th.
8:30.
4th at 8:30.
Thank you. I'm still looking forward to getting out of here.
You preempted your vacation date.
I will also be gone in August.
Okay. I don't know how they'll get by without us.
I don't know.
Yeah, the system will stop. All three of us. I'll be gone.
I heard all the crime will stop.
All right. So we'll reset this for August 4th at 8:30. We'll do a writ accordingly. D to be writ out of Clinton County, although we did one this time. We'll do it again. Out of Clinton. Anything else for the record? Docket 2203252, Mr. Marshall.
No, Your Honor, I believe that would handle that.
All right, Mr. Abbott?
Nothing further. Thank you, Your Honor.
Thank you. We're all set.